followed by our discussion period, and then we'll have a coffee break. I was informed, based on my own poor performance with the mic, that everyone speaking should actually have the mic quite close to their lips so that it can be well heard. I was also informed during the lunch break that we had, I believe it was about 1,500 hits on the internet, and I would like to encourage everybody to be very clear when they speak, because it's all going through our wires. Thank you. I wish to invite Mr. Michael Lodge. He's the legal counsel of the International Seabed Authority. I wish to invite him to give a presentation on deep sea bed mining provisions, regulations for prospecting and exploration in the area. Michael.
Thank you very much. Good afternoon, everybody. I hope everyone had a good lunch. No doubt the best thing after a good lunch is to go for a walk on Copacabana Beach. But I'm afraid you're going to have to sit here and listen to a lawyer. I am going to talk about the regulatory regime for deep seabed mining. It's a very interesting interface between public international law, commercial law, private international law, and contract law. Now, I know there are some lawyers here, there are representatives of many other disciplines, so what I want to try to do in this presentation is to encourage you to look at the regime from your own particular perspective. And of course, at the end, in the discussion time, to ask any questions and bring forward any issues that you might want to discuss. Okay, next slide. I want to emphasize from the outset that what we are talking about here is the regulatory regime for the area. That is the area shown on the map, the area beyond any national jurisdiction. It's very important to understand that we are not talking about areas within national jurisdiction, nor are we talking about areas of continental shelf. And let me also explain, as a way of disclaimer, that this map does not show the potential areas of outer continental shelf that may extend beyond 200 miles, because, for obvious reasons, those areas are not yet finally delineated. But this gives you a sense of the extent of the international area. Next slide. In the presentation, I want to go very quickly through the sources of law and the fundamental principles on which the regime is based. Then I want to talk for a while about the mining code, and then I will go on to look at the prospecting and exploration regime covering polymetallic nodules. Next slide. Okay, the sources of law. Click, please. The first one, as you've heard this morning, is the 1982 UN Convention, in particular Part 11 and Annex 3 of that document. Click. The 1994 Implementation Agreement. Click again. The rules, regulations, and procedures of the International Seabed Authority, and that will be the main focus of my talk this afternoon. And click. And other rules of international law not incompatible with the convention. Now, primarily here, we mean rules of international law that relate to taking ships to sea and other activities at sea. For example, the Dumping Convention. Next slide. Some of the fundamental principles, the Secretary General dealt with some of these this morning, but they are worth reinforcing. The area and its resources are the common heritage of mankind. What does that mean? Well, in the first place, there shall be no claim to sovereignty over any part of the international area or its resources by any state. Any claim made outside the convention regime, therefore, is not recognized. All rights in the resources are vested in mankind as a whole. that mankind is represented by the International Seabed Authority for this purpose. No state or natural or juridical person shall exercise mineral rights without the consent of the authority. They must act in accordance with the convention and the agreement. The area is exclusively for peaceful purposes. You can't go and put missiles on the bottom of the sea. And finally, that activities in the area shall be carried out for the benefit of mankind as a whole. So the benefits, the economic benefits from exploitation of the resources are to be used for the benefit of mankind. Next slide. The mining code. What do I mean by the mining code is the comprehensive set of rules, regulations, and procedures to be adopted by the authority. They will regulate all phases of mineral exploration and exploitation in the international area. Click, please. So the mining code will cover various aspects. It will cover the phases of prospecting, exploration, and exploitation, including the financial terms on which exploitation is to be permitted. It will contain various rules and procedures that will cover, for example, environmental recommendations, it will cover data standards, and it will cover different kinds of resources. Click, please. It will cover nodules, it will cover sulfides, it will cover cobalt-rich crusts, and any other resources that may be there that we don't know about, providing, of course, they are mineral resources. Now, the mining code is not yet complete. Could you click, please? So far, the areas in yellow are the parts that have been completed. If you're from the private sector, you probably have a question mark already, because you can see that we have not yet elaborated the section on financial terms. So even if you want to take an area for exploration and future exploitation, you don't not yet know how much it's going to cost you. It's taken about 10 years to reach this stage of development of the mining code. As you see, there is still a long way to go. We're currently working on the regulations for sulfides and crusts, but they're by no means complete. Next slide, please. Now, in this part of the presentation, what I want to do is to outline to you the way in which a contractor might apply for an exploration license for prospecting and exploration for polymetallic nodules, that being the part of the mining code that is completed so far. Click, please. What an application can bring you at this stage is a 15-year contract that would give you exclusive rights for exploration over a particular area. Next slide. So, who can apply? Well, there are certain eligibility criteria. To be a qualified applicant, could you click? You must be either a state that is a party to the convention, click, a state enterprise that is sponsored by a state party, that is a national corporation, for example, click, or you may be a natural or juridical person, a private sector entity, but you must possess the nationality of a state party and you must be sponsored by a state party. So clearly, state sponsorship is one of the critical factors in the convention. Click, please. That sponsorship by a state must be evidenced by a certificate of sponsorship from the state concerned and by a declaration that that state will assume responsibility. And we'll cover that factor a little more later. Next slide. Every application must contain certain elements, and these are set out on this slide. There must be information relating to the financial capacity of the entity and its technical capacity. Does it have the resources to carry out an exploration program in terms of money and in terms of technical know-how and expertise. The application must set out the details of the exploration program. In particular, there must be a detailed 5-year plan that includes anticipated actual and direct exploration expenditure. There must also be a proposal to carry out oceanographic and environmental baseline studies, as well as a preliminary environmental impact assessment. The application must contain the details as to how the applicant proposes to prevent pollution. There must be an undertaking signed by the appropriate entity that the plan of work for exploration will be carried out in good faith. And there must, of course, be a fee, very important for the authority. And the fee at the moment for plans of work for polymetallic nodules is $250,000 per application. And finally, of course, there must be a list of coordinates and a chart showing the area that the applicant wants to explore. Next slide. Now let's look at the area of application. In making an application for polymetallic nodule exploration, the convention actually requires that you propose 2 sites. And these must be 2 sites of equal estimated commercial value. Eventually, one will go to the contractor and one will be reserved for the authority. And I'll talk a little bit later about what that means. Click. Each site can be up to 150,000 square kilometers in size. Click again. It does not need to be a single block. It can be any geographical configuration whatsoever. Click again. And as you see from this chart that shows the existing contract areas, there are all sorts of different geographical configurations. Some of them are single blocks. Some of them, for example, the blue one on the left and the red one, are divided up into all sorts of small, non-contiguous areas. But the contractor, or the applicant, is free to define the prospective site in whatever way it thinks fit. Next slide. Okay, once the application is made, it goes to the authority's Legal and Technical Commission. And you heard about that body this morning from my colleague, Mr. Dunton. The Legal and Technical Commission will consider the application, and it makes a recommendation, click, to the Council. Now, the Council has very limited powers. In fact, the Convention and the agreement provide that the Council shall approve the application, must approve the application, unless it is disapproved by a 2/3 majority that must include a majority in each chamber. There are 5 chambers, as you heard this morning, so if you think that through, it is extremely difficult for the Council to reject a plan of work for exploration. Click. Once the application is approved, then it must be issued in the form of a contract, which is made between the Secretary General on behalf of the authority and the contracting entity. Next slide. So let's have a quick look at the terms of an exploration contract. Click. Okay, as I've mentioned, it's 15 years. There is a possibility in exceptional circumstances of extensions being made for 5 years at a time. The area is 150,000 square kilometers, which has to be reduced over a period of 8 years by a process of relinquishment to 75,000 square kilometers. The contract must include a training program for the benefit of developing countries or personnel from developing countries at the expense of the contractor. And the contractor also gets, as one of the benefits of the contract, a preference and a priority over any other applicant for future exploitation of that same area. Of course, if the contractor does not proceed to exploitation, then he loses that preference, and somebody else could take the area. Next slide. Environmental protection is something that is very important, and the contracts contain very strict terms for environmental protection. The strict obligations on the contractor: they must apply a precautionary approach, they must establish environmental baselines, and they must cooperate with the ISA in terms of environmental monitoring. This includes a requirement that they submit environmental data and annual reports on their activities, and they must at all times maintain a contingency plan in the event of any emergency. That plan must be deposited with the Secretary General. To assist the contractor in carrying out these environmental obligations, the Legal and Technical Commission issues from time to time recommendations which go in very great detail as to the sort of environmental tests and baselines and so on that the contractor must follow. Those were issued in 2001 and are currently under review with a view to updating them. Next slide. Confidential data and information is a very important aspect of any mining contract, particularly from the point of view of commercial contractors. The regulations and procedures recognize this, and there are very strict limitations on the use of and access to any data that may be considered confidential. The convention itself imposes liability, which is personal liability, on the Secretary General and all staff of the authority to safeguard confidential data. There are two important aspects to highlight. One is that environmental data and information is never considered confidential, because that must be used by the authority and the Legal and Technical Commission for the benefit of the environment and to develop further environmental rules. And secondly, as a counterbalance to that, that proprietary data and information owned by contractors and developed for the purposes of mining, for example, equipment design data, is always considered confidential. Next. The contract covers responsibility and liability. As you see, there is a counterbalance. The contractor is held liable for damage to including damage to the environment arising from its wrongful acts, but at the same time, the authority also is liable for any potential damage, including the liability for the misuse of confidential information. Furthermore, one of the important aspects of the relationship between contractors, the authority, and sponsoring states is that the sponsoring state itself would remain liable for the actions of its contractors unless it can show that it has taken all necessary and effective measures to secure compliance by its nationals. Next. There are certain circumstances in which a contract may be suspended or terminated. That may arise where there is a termination of sponsorship. If a contractor loses the sponsorship of its sponsoring state, then it has a certain amount of time in which to find another sponsor. If it fails to find another sponsor, then the contract is to be terminated. There must always be a sponsoring state. If there are serious, persistent, and willful violations of the contract, then it may be suspended or terminated. Equally, if there is a failure to comply with a final binding decision of an applicable court or tribunal. Of course, if a contractor becomes insolvent, then the contract also is terminated. Now, the council has power to impose monetary penalties on a contractor for breaches that fall short of serious, persistent or willful breaches. The extent of those penalties is not specifically set out in the convention or in the regulations, and it remains to be seen how that might be applied in practice. An important point to mention is that disputes are to be settled in accordance with Part 11, Section 5 of the Convention. No doubt we shall hear more about the jurisdiction of the International Tribunal for the Law of the Sea in due course, but the important point to draw out for the purposes of this presentation is that we have a very novel situation in international law where both private contractors or state contractors and an international organization have recourse to an international tribunal for matters arising under Part 11 of the Convention. And this is a very unusual and novel provision that assures equal rights to both public and private sectors. Next. Okay, the reserved areas, I'd mentioned those earlier. The reserved areas, remember, when an application is made, a contractor must propose 2 sites of equal value. One is kept by the contractor, the other one goes to the authority. Well, all those that the authority is currently holding are shown in white on this slide. So what's the purpose of that? What is the authority to do with those? Click, please. Okay, those sites, which are supposed to at least to be of equal value to all the other sites that are being explored by actual contractors, are open for application by the following. Either a developing state party in its own right, or a natural or juridical person that is sponsored by and effectively controlled by a developing state. This is part of sharing the benefits of the international area for all mankind as a whole. The advantage that the developing state or its national gets is that all the preparatory work to prospect those reserved areas, to be sure that they contain enough in the way of resources to be worth exploring further, has already been done. So you can come to the authority as a developing state party and ask for any of those reserved areas and be given providing you comply with all the other requirements, be given a 15-year exploration contract. So this is designed as a benefit for developing states. They are entitled to take those areas provided that the enterprise, which is designed to be the commercial arm of the authority itself, does not plan to take those areas. At the moment, the enterprise does not exist in reality. It exists in the convention, but so far steps have not been taken to activate the enterprise. So in effect, it's unlikely that the enterprise would take any of those areas, and they may be considered available for applications by any developing state. There is a final exception in the convention, which is actually contained in more complex terms than is set out here. But if those sites are not used within 15 years, they may, in certain circumstances, revert to the entity that originally donated those sites. So that is a very quick overview of the regulations as they exist at the moment. Remind you once again that They cover only the phase of exploration at the moment. It's estimated at least a 15-year phase. There will be a need in the future to develop further rules, regulations, and procedures governing actual exploitation. But this is what we have at the moment. And anyone who wishes to make an application is most welcome to do so and can see me afterwards. Thank you.